Good afternoon, and thank you for joining us here at Central State University as we celebrate Constitution Day. I'm Dr. Jack Thomas. I'm the 9th president of Central State University, and it is my pleasure to welcome all of those who are participating in this presentation in person and those who are joining us via live stream. We're pleased to share this presentation with students from the Columbus City Schools, Cleveland Metro Schools, Cincinnati Public Schools, the Dayton Early College Academy, and other students as well. I would also like to thank the college, the Honors College at Central State University, and Dr. Paul Slagg for hosting this. President Barack Obama once said, "As Americans, we can take pride in the fact that our courage has been inspired by our own struggle for freedom, by the tradition of democratic laws secured by our forefathers and enshrined in our Constitution. It is a tradition that says all men and women are created equal under the law and that no one is above it. Today, we celebrate a document that continues to inspire our struggle for freedom. Understanding the Constitution is important for all citizens. A concern for the lack of basic civic knowledge led Ms. Louise Lee, a senior citizen from Pomona, California, to build a national campaign to celebrate the U.S. Constitution. Ms. Lee was a lifelong learner and a civic leader who, among others activities, volunteered to teach English to new immigrants and tutor at-risk school children through the New Revolution Baptist Church. In her early 80s, Ms. Lee enrolled in a course on the U.S. Constitution. The class inspired her to further promote the Constitution, and in 1997, at the age of 83, she founded National Constitution Day, Incorporated. Through this organization, Ms. Lee lobbied Congress and convinced Senator Robert Byrd to include a Constitution amendment in the 2004 spending bill. The bill subsequently became law and took effect in 2005. Under the law, every educational institution receiving federal funding must celebrate the U.S. Constitution each year on or near September 17th. Recall that September 17th was the date that delegates to the U.S. Constitution approved the document and sent it to the states for ratification. At Central State University, we are proud to celebrate Constitution Day by hosting this presentation by Dr. Richard Hardy. Dean Hardy served as leader of the Centennial Honors College at Western Illinois University from 2011 to 2020 and is currently the Dan Webb Endowed Chair of Political Science at Western Illinois University. He graduated with honors from Western Illinois University's Political Science Department and earned an MA at the University of North Dakota and a PhD from the University of Iowa. He has nearly 50 years of college teaching experience, serving on the faculties of Northern State University, the University of Missouri-Columbia, Duke University, and Western Illinois University. His areas of expertise include U.S. constitutional law, civil rights, civil liberties, public policy, and American politics. He has nearly 50 publications, including books, anthologies, peer-reviewed articles, and book chapters. In fact, he may have written the textbook the students joining us today are using in their classrooms. Dr. Hardy's administrative positions at the University of Missouri included Assistant Director of the Honors College, Director of Undergraduate Studies, Director of the Master's Program in Public Policy, Director of the National Institute for Advanced Civic Student Studies, Director of Internships, and founder and director of the Institute for Leadership in Civic Education. At Western Illinois University, he served as the chair of the Department of Political Science and led the Centennial Honors College to national prominency. Dr. Hardy has also served as a political analyst for numerous media outlets such as CNN, NBC News, Fox News, and the Associated Press, and has been quoted extensively in various print outlets such as Newsweek, USA Today, the New York Times, U.S. News and World Report, Kansas City Star, Parade Magazine, and the St. Louis Post-Dispatch. Today, he has garnered over 60 significant teaching and civic leadership awards, including the University of Missouri's four-campus Burlington Northern Faculty Achievement Award, the prestigious William Kemper Award, the Missouri Bar Association Civic Educational Award, and two campus nominations for the Case National Professor of the Year Award. At Western Illinois University, he won several campus awards and was selected to deliver the John Hogwarts Lecture in the Liberal Arts. Dr. Hardy is a remarkable constitutional scholar, and his Constitutional Day speech is entitled Expansion of the Bill of Rights through the 14th Amendment. Please join me in welcoming a constitutional scholar, Dr. Rick Hardy.
President Thomas, it's an honor to be at Central State University and to have you introduce me. I've been introducing you for a long time over the years. You're a remarkable public leader and a man of great principle, a great vision, and I think Central State University is very fortunate to have him at the helm. I also want to thank Dr. Paul Schlag, the head of the Honors College here at Central State, for inviting me to be part of this today. I want to talk about, obviously, the Constitution. The Constitution is an amazing document. I want you to think about how this Constitution works and what it's about. The Constitution is a very short document. It's also a very revered document. It is now 232 years old. In fact, it is the oldest written nation-state constitution in the world. Somebody might say, well, what about the Magna Carta, 1215? Well, the Magna Carta is a great document, but the Constitution of Great Britain is whatever the Parliament wants to do. No, we have a written constitution. And the oldest other old constitution, the next most senior constitution, is that of Norway in 1814. If you look at the United Nations, you'll find there are 193 members of the United Nations. Of those nation states, over half of them have written constitutions since 1970. So you can see ours is an old document. Not only is it a fairly old document, it is a very short document. It is altogether 7,606 words long. Today, if you had a chance, refer to the students in this classroom, to read the sports section of the USA Today, you have read more words than the U.S. Constitution. It's an amazingly short document. It contains a preamble or a short introduction. We, the people of the United States, in order to form this more perfect union. We have 7 articles or similar subdivisions. Article 1 begins, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. Article 2 deals with the presidency. The executive power shall be vested in a President of the United States. The article goes on to list the qualifications and powers. And Article 3, the judicial power shall be vested in one Supreme Court and such inferior courts as Congress shall from time to time ordain and establish. Article 4 deals with interstate relations and the obligations the national government has to states. Article 5 deals with the amendment process. Article 6 has a very important provision called the Supremacy Clause in Section 2. This Constitution and all laws passed pursuant and treaties under the authority thereof are the supreme law of the land. We'll talk more about that in a little bit. And Article 7 is to how this Constitution is to be ratified. It required 9 of the 13 original states. Today, we have that document plus the Bill of Rights, the first 10 amendments adopted in 1791, which means that this document, the Bill of Rights, is now 230 years of age. Then we have 17 additional amendments, so altogether 27. It's not a very long document, but yet it's provided us a durable, workable framework upon which our government exists. It is not some dust-covered relic, and it would behoove all of us to study this document. Now, before I talk about the Bill of Rights, I'd like you to all just imagine for a moment, those of you who are in classrooms throughout high schools and those of you who are in the audience, I'd like you to imagine that there is an island out in the Pacific. No one has ever really seen it except for the group that lived there, the tribe that lived there. It doesn't know anything about computers. It doesn't know anything about airplanes. It is a very primitive tribe. They live together. They have plenty of bananas and coconuts and fish to eat, and they live a wonderful life. Unaffected by, quote, civilization. But sometimes they have problems in this tribe. And so what they do is when they have problems they can't solve right away, is the chieftains, the elders, go up into a cave, and they walk into the cave, and there on the floor of the cave is a skull. The skull is from the founders of their tribe. And there they will consult with the skull as to the situation at hand. Once they arrive at the decision, they come down off the mountain and they tell the tribe what the decision of the skull is and how to resolve their issue. Now, on October, in the first Monday of October, the U.S. Supreme Court will begin session. It will be in session until July. And on Mondays, Wednesday afternoons, I'll take it back, Wednesday afternoons and Friday afternoons, they have a conference. There's a conference room right outside of the Chief Justice's office. It's rather small, about the size of a classroom or smaller. And in this room, there's a table, if you can picture this. It's a rectangular table with 9 chairs around it. There are legal pads on each, in front of each seat. And in the center is the United States Constitution. And on Wednesday afternoons and Fridays, the United States Supreme Court has to determine what is or it is not constitutional. Is it constitutional, for example, to have lethal injection? Does that violate the 8th Amendment's cruel and unusual punishment? Can the President, through an executive order, require all businesses with 100 or more employees to be vaccinated or lose their job? Is a pregnant woman driving alone in a commuter car lane only constitute a carpool? Now, I know that sounds silly, but these are the kind of questions that the U.S. Supreme Court has to deal with all the time, and they divine what's in the Constitution. I'm sure there's something in there about COVID shots in there. I'm sure you're going to find something in there about a pregnant woman driving on a commuter lane. I'm sure you're going to find something in there about lethal injection. No, you won't. But the Supreme Court will render a decision, and then they will announce it probably the next Monday as they come through their velvet, with their robes, and they come through these velvet curtains, and they announce what the Supreme Court says. And the reporters write on it, this is what's constitutional or not constitutional. Class, and for those of you watching on the screen, I ask you, what is the real difference between that so-called primitive tribe and what the United States Supreme Court does? You see, as Charles Evans Hughes, Chief Justice of the Supreme Court, once said, the Constitution is what a majority of justices say it is. and we believe it, and it becomes the law, and we are guided by that. So you have to understand what's in the Constitution, what's not. When the Constitution was written in 1787 and sent out to the states, where it required 9 of the 13 states ratify it, immediately there was a stiff opposition. The so-called anti-federalists, Eldridge Gerry, DeWitt Clinton, Patrick Henry, and George Mason. George Mason was a delegate to the Constitutional Convention for representing Virginia, and he left. They were upset because they thought that there were too much powers given to the national government relative to the states. One of the most important criticisms was that there was no Bill of Rights. Indeed, George Mason said, I would rather cut off my right arm right now than to sign this document as it presently exists without a Bill of Rights. They were terribly afraid of the growing power of the national government. It looked as though we would not have a constitution. It would not be ratified. But a deal was made. George Washington told James Madison, the leader of the Federalists, to make a deal. He and George Mason, who are both from Virginia, hammered out a promise. The promise was this: if the document is going to be ratified, that the Federalists agreed that once the new government was formed, they would entertain amendments to the Constitution. On March 4th, 1789, in New York City, which was our nation's first capital, Congress convened for the first time, and George Mason and James Madison announced that they would take suggestions and proposals for new amendments. I believe this may be the first and only time in recorded history where Congress ever kept a promise. I'm being a little bit facetious by this, but it shows that there was agreement. And immediately, there were about 125 proposals to amend the Constitution. Most of those were poorly drafted. Government ought not to do this. Government ought not to do that. George Mason was an attorney. He was the attorney that took and pulled these together, along with James Madison, a philosopher, a political philosopher. And together they came out with, eventually, 12 amendments passed. 12 amendments, that's the key, 12 amendments passed the U.S. Congress and were sent out for the states. 10 of those were eventually adopted and became the so-called Bill of Rights. If you'll notice that there were 2 amendments that did not get ratified, well, at least immediately. The original First Amendment, and I think you should be glad that it did not get amended, because it called for 1 representative for every 30,000 people. Today, if the census is correct and we have 330 million Americans or inhabitants, that would mean we'd have over 11,000 members of Congress today. Wouldn't that be like herding squirrels today? It's bad enough when we have 435 to keep track of them. That did not get ratified, and that amendment is dead. But the original Second Amendment brings up something I think is important. Years ago, about 25, 30 years ago, there was a student, a 19-year-old student by the name of Gregory Watson. He was at the University of Texas, Austin. He was taking a political science class from Professor Sharon Waite. Professor Waite gave him a term paper to do about processes of the government, Congress, President, Supreme Court. Not wasting any time, Gregory Watson, a 19-year-old, went over to the archives of the university library, and he went through books, and he discovered a book on amendments. And he discovered that there were no time limits on the original amendments. Indeed, the Second Amendment, the original Second Amendment, not the right to keep and bear arms, but the original Second Amendment was that there's indeed no pay raise to a member of Congress until an election is intervened. That is, so they can't give themselves pay raises. The young man thought this was interesting and wrote the paper on it. He got a C. He was very disturbed by the fact he got a C. He talked, Professor, it appeared seemed like he didn't even grade the paper. She said, well, I just didn't think it was very interesting. Well, he took the C, and then he decided to make some changes. He decided that there were no term limit, there were no time limits on this, so he started writing the state legislatures. He wrote to the state legislature of Vermont and Maine, and he caught somebody's attention there. There's a William Cohen, state senator, said, you know, you've got something here. Can those be ratified even after new states have been added? There were only 13 states, now we have 37 additional states. Well, guess what? It caught fire. And today, it is now the 27th Amendment of the Constitution. The 27th Amendment of the Constitution is the original Madison Amendment, and it is the work of a 19-year-old college student who was a C student who decided to take no, wouldn't take no for an answer. It's a great lesson in civics right there. Well, the Bill of Rights is this, and I want to make this clear. The Bill of Rights is a check on the national government. I'm clear on this. That was the intended impact. It was not a check on the states. If you read the very first words of the First Amendment, Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. Notice it doesn't say state government shall make no law. It says Congress shall make no law. You see, the founders were fearful that the national government would grow too powerful. So the restriction always, with the Bill of Rights, were intended as a restriction on the national government, not the states. And indeed, it wasn't until 1925, in a case called Gitlow versus New York, that for any part of the Bill of Rights that were extended to the state governments. Now, by the way, I want to make clear, the Bill of Rights is a restriction on the national government, and I'll show you how it's grown to include the state government, but it's not a prescription on individuals. I hear some people say, well, I was at Walmart and I heard somebody got fired for cussing out so-and-so. Don't they have the First Amendment right? No, you don't. It only protects government against government action, not private individuals. So, let's get back to this. How did this happen? Well, I have to digress for just a moment. Oh, let me mention. There were tests in the Supreme Court on whether or not the Bill of Rights applies to the state. One of the early cases occurred in 1833. A case called Barron versus Baltimore. John Barron owned a fishing wharf in the deep harbor of Baltimore. And he and his partner had a lucrative business. And then, one day, without consulting him or the other owners, the city diverted natural streams, and it led to a diversion of those streams into his harbor. It would build up silt and muck that he could not operate. He was without recourse. So he thought, I don't find any state law that I could use to challenge this, or any city ordinance. So he looked at the Bill of Rights. I have on your tables there, for those of you who are here in person, and we'll put these on the website, the green page. If you look at the, I think it's the green one. Yeah, the green one. It has, look at Amendment number 5. It says, nobody shall lose their property without just compensation. No one shall be denied their life, liberty, or property without due process. So he tried to use this. He sued and won $2,500 in a local court, but the state of Maryland reversed it and said, you can't do that. It went to the Supreme Court. Does he have recourse under the Fifth Amendment? John Marshall, the 4th Chief Justice of the United States, arguably the most powerful ever, looked at this and said, I'm sorry this happened to you, but you cannot use the Fifth Amendment. You're trying to limit what the city and the state is doing. You have no recourse because the Fifth Amendment only applies to the national government. There was another case in 1844, there was an outbreak of disease in New Orleans, cholera. And the state mandated that all corpses and all events had to take place at one particular cathedral. There was a man who died, and Louis Leroy passed away. And Father Bernard Pernoli decided to have a mass for him in the church of his choice, and it was not the prescribed one by law. He was fined, and he said, wait a minute, this is a violation of the First Amendment, freedom of religion. It went to the Supreme Court. Supreme Court, no, you don't have a case. The First Amendment only applies to the national government, not the states. Now, what changed this? Well, we have to take a little bit of a diversion, and I have to go back to probably the most infamous case in the history of Supreme Court. It's a case called Dred Scott versus Sanford. I hope you should know this case. It's one of the most important, and it's an awful case in terms of U.S. history. To understand this case, you have to understand that in 1820, Missouri wanted to enter the Union. The problem was, if it entered the Union, was it a slave state or a free state? The Senate was equally balanced between slave states and free states. Equally balanced, and each state has 2 senators. So there's a balance, a tie. If you added Missouri as a free state, it would tip the balance to the south. If you added Missouri as a free state, it would tip to the north. So a compromise was reached. They took Massachusetts, divided it up, and it became Maine. Maine was originally part of Massachusetts, and it became a free state. And under the Missouri Compromise, you have Missouri coming in as a slave state and Maine coming in as a free state. Well, what does this mean? Well, many years later, there's a man by the name of Dred Scott, born into slavery, circa 1795, and he is owner, a Captain Blau from Virginia, moved to Missouri, St. Louis, Missouri, the slave state, under the Missouri Compromise. When they reached there, the owner died, and he was sold to a Captain Emerson, who was a physician in the U.S. Army. Captain Emerson then took Dred Scott with him when he moved to Rock Island, Illinois, and later Fort Snelling. Rock Island, a free state. Fort Snelling was a territory free under the Missouri Compromise. When they returned, guess what? The owner died. And Dred Scott was turned over to Mrs. Emerson, Irene Emerson, and she says, I don't like slavery, and I don't like St. Louis. I'm going back to New York. So she left Dred Scott when trusted to the 2 original owners' sons, the Blau brothers. One was a wealthy individual, an attorney. The other was the owner of a railroad company, and they were abolitionists. They wanted Dred Scott to bring they could have freed him at any time. What they did was they established a lawsuit. They brought a lawsuit, originally called Dred Scott, a Man of Color versus Emerson. They won at the St. Louis court. They went to the Missouri Supreme Court where it was reversed, and they were about ready to file a case to the U.S. Supreme Court. Unfortunately, another case in Kentucky came out at that same time, so they had to change course. How do we get the case to the Supreme Court? So they arranged a phony sale of Dred Scott to Irene Emerson's brother, Mr. Sanford, in New York. That creates a diversity case. It gets into a federal court, and then they appeal it to the U.S. Supreme Court. The question is, does Dred Scott, were his rights trespassed, that was the term they used, trespassed by the fact that he went from a free state, slave state, to a free state, back to a slave state? Well, the case went before the Chief Justice, 5th Chief Justice. His name was Roger B. Taney. He was a racist by any stretch of the imagination. He and his family had owned slaves. He believed in states' rights. There was no way that Dred Scott was going to win this. So he announces this. He says, Dred Scott cannot bring a lawsuit because he was not a citizen when the Constitution was written. And therefore, he has no standing to bring a lawsuit. He could have ended it right there, but he went on to say, by the way, the provision of the Missouri Compromise of 1820 that proscribes slavery in the states and territories is unconstitutional because it violates the 5th Amendment. Congress just violated the 5th Amendment by creating this proscription. And what did he say? No one shall be deprived of life, liberty, or property. What was the key word? The key word was property. Dred Scott was seen as property, not as a citizen, not as a person, not as just property. Well, this was a display that went down tough, hard on everybody, because it was a sign that we could not resolve the slavery issue. It led ultimately to the Civil War. After the Civil War, Congress enacts 3 very important civil rights amendments. The 13th Amendment prohibits slavery and indentured servitude. The 15th Amendment, yes, I skipped the 14th. The 15th Amendment allows black men the right to vote, not black women. Women didn't have the right to vote until the 19th Amendment. And the 14th. Let me say something about the 13th. We skip over it. That's a very important thing, to end slavery in the Constitution and indentured servitude. There is something about the 13th Amendment that most people do not know, and if you get this today, you'll know more than 99.9% of the American people, and most lawyers. The 13th Amendment is the only provision in the Constitution that is a restriction on individuals, not state or government, federal government. You understand that? It means that people can be prosecuted under the 13th Amendment for slavery. And Congress has passed a number of laws, Peonage Act, that's what we call them, the Peonage Act. For example, if today the Sultan of Impapamau would visit, I made that up by the way, would visit New York City and bring 20 of his slaves and keep them in the penthouse in New York City and not let them go, he could be prosecuted in federal law under our peonage laws. Under our peonage laws. It raises some interesting questions. But I want to talk about the 14th Amendment. I have it there on that green sheet. You'll see at the bottom. All right. The bottom is this. It says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the states wherein they reside. You see that? All persons born in the United States are citizens of the United States. That provision makes Dred Scott null and void. You understand that? That provision makes Dred Scott null and void. And by the way, the person who wrote that amendment is John Bingham from the state of Ohio. He was the person who had, he actually was involved in the prosecution of the conspirators to assassinate Abraham Lincoln. And he was also the chief prosecutor for the impeachment of Andrew Johnson, a very important person in Ohio history. But the 14th Amendment makes it clear that no state shall deny anyone equal protection of the law, due process of law, or privileges and immunities. This has become the vehicle in which to absorb the Bill of Rights. Now, there are those that believe that when John Bingham wrote the Bill of Rights, he intended the 14th Amendment to absorb all of the Bill of Rights. That's called total incorporation. And indeed, there's one justice of the court advocated that for years and years and years. His name was Justice Hugo Black. He believed that the 14th Amendment absorbs the Bill of Rights in total. In total. And how did he do that? Because he looked back at what John Bingham did, his intentions. He relied upon a historian by the name of Horace Flack. Problem is, Horace Flack was not a particularly good historian, and he often got things wrong. The point of fact is, if John Bingham wanted the Bill of Rights to be absorbed by the 14th Amendment, they would have said so in the amendment. They didn't. But it has been used selectively. Now, there was a case called Palco versus Connecticut in 1937. It was a case in which a man had killed somebody in a robbery. He was robbing in Hartford, Connecticut, he was robbing a music store, and he killed 2 police officers. He was tried, and he was convicted of second-degree murder, but the judge made errors, many procedural errors. Talk about this as a key case of criminal procedure class. Terrible procedural errors. The state appealed, and the state won an appeal. He was retried. He got off on second-degree murder, but he was retried, and he was found guilty of first-degree murder and sentenced to death. He argued that this violates a provision of the Constitution in the 5th Amendment that no one shall be tried twice, in this case, or for the same crime, or no one shall be placed twice in double jeopardy. Well, it went to the Supreme Court in 1937 and said, well, that's not essential to the scheme of order of liberty. Right to trial is the right to free speech, but that's not one of it. It would take many years, 1964, before that case was reversed. But the point is this: on a case-by-case-by-case basis, the Supreme Court, on a piecemeal, has enlarged the Constitution by expanding the Bill of Rights through the incorporation of the Due Process Clause so that it applies to both governments. Now, what do we mean by that? Today, all of the First Amendment has been incorporated. If you look at that, I think it's the yellow sheet that I handed out. The yellow sheet you can see on a case-by-case basis. Never all at once. First a case on free speech, another case on free exercise, another case on freedom of the press. All of that has been incorporated. That applies protection against both governments. The Second Amendment. Did you know it was not until 2010 that the Bill of Rights was, of the Second Amendment, the right to keep and was a prescription only against the national government. It wasn't until a case out of Chicago. An African-American man by the name of McDonald. An older gentleman had had his house burglarized several times. He went to get a gun. It became impossible for him to own a gun because the city laws were such that it was virtually impossible. So he brought a lawsuit, and for the first time ever, in 2010, McDonald versus Chicago, the Supreme Court ruled that the Second Amendment applies to both governments. The Third Amendment does not apply. There is not a case ever before the court about ordering a soldier. I don't know if you have ever worried about this. Perhaps some of you have worried about the government knocking on your door and saying, we're soldiers, we're going to stay all night tonight. That was a throwback to colonial period. So it's a historical artifact. But the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated, and no warrant shall be issued upon probable cause. You know, we have an exclusionary rule. Did you know that's an American invention? That came up in a case in 1914, U.S. versus Weeks. There are some people that said you should never let the criminal go free because the constable blundered. But the exclusionary rule and the rule in regard to the Fourth Amendment applies to us today. The Fifth Amendment, all of that has been absorbed by the 14th Amendment except one provision. It's the grand jury provision. Did you know that if you're charged with a crime at the federal level, you can only be charged with the grand jury? States can use whatever method they want to. The Sixth Amendment has been totally absorbed, the right to counsel, the right to a public and speedy trial. The Seventh Amendment has never been absorbed. This is a guarantee of a trial by jury in cases, civil cases with $200 or more, $20 or more. This is a terrible provision of the Constitution. It's never been absorbed. The Eighth Amendment has, in regard to cruel and unusual punishment, has been absorbed. It applies to both governments, except for one provision. And that is, if you look at the Eighth Amendment, bail. States can deny bail if they want to, or they could just go away and do without bail. States are free to do whatever they want to. But the fines, do you see that? No excessive bail or fine. I'll have one last case. If you notice on the last sheet, I have a case called, it was a 2019 case. It was a case called Trimble versus Indiana. You see that? This has to do with forfeiture. We have a Mr. Trimble. Mr. Trimble has drug problems. His father passes away, and he inherits his father's estate, insurance, considerable amount, and immediately he goes out and spends the money. Buys a $42,000 Land Rover. He spends it on lavish things, and he spends it on a lot of things he doesn't need. He soon went through the money, and then he had to sell drugs. He sold drugs to an undercover agent for $225 worth of marijuana. He was busted. He went to jail. He was convicted. He had to spend 1 year home sentence. He had 5 years probation. He had to pay a $1,200 fine. But the state used the forfeiture laws, and they went after the vehicle in which he sold the drugs, the Land Rover, $42,000 Land Rover, and they took it. They confiscated it. They do that all the time. He brought a lawsuit. He said that's an excessive fine because the maximum I would have been fined had I been found guilty to the hilt of the law, the elder of the law, would have been $10,000. This is excessive. The U.S. Supreme Court took that case in 2019, and a unanimous decision written by Ruth Bader Ginsburg said, no, this is excessive. This becomes the first case ever to apply excessive fines to the state. The Ninth Amendment has never been incorporated. It's the rights retained by the people. That's a very difficult one. It's been used in regard to privacy rights, which is not found in the Constitution. But it's been used, the 10th Amendment has never been absorbed. So here's what I'm saying. The Bill of Rights applies to the national government, all of the First Amendment, all of the Second Amendment, all of the Fourth Amendment, all of the Sixth Amendment, part of the Fifth Amendment, part of the Eighth Amendment, but it has not absorbed the Third, It has not absorbed the 7th, the 9th, or the 10th. Now that sounds rather strange, doesn't it? But that's the way the court is interpreted. It's an amazing document. To understand the Constitution, you have to learn what the cases are. It's an intriguing study. I hope that today I have at least given you some idea of what's going on in regard to constitutional law, constitutional theory. It behooves you to understand it. It's a great document. Will it last? Nothing lasts forever. As George Harrison once said, all things pass. This building, a magnificent building, would deteriorate in 100 years if nobody took care of it. The Constitution will too if you don't take care of it. Take a look at it, understand it, understand about the justices on the court, how it works, and pay attention to those Supreme Court decisions, because that will determine what the Constitution means. I want to thank you, Dr. Paul Schlag, Dr. Jack Thomas, for having me here, all the wonderful people at Central State University. I hope I can come back many times. I think you're on a wonderful journey here. It's going to be a wonderful operation you have here, and wonderful students. I appreciate to be here. And for all of those of you out in high schools watching this, I hope you email me at Western Illinois University if you have any questions. I want to thank you for this opportunity. Thank you very much.
Thank you, Dr. Hardy, for such wonderful information and a wealth of knowledge here that you've given to our students here, as well as those who are joining us online. Let's give Dr. Rick Hardy another round of applause. I also want to thank Dr. Schlag, our Executive Director of our Honors College, and his staff. Let's give them a round of applause as well. And I want to thank all of you for joining us here for Constitution Day here at Central State University. This concludes our program. Thank you so much for joining us. Thank you.